Hello, and welcome to Raising the Bar with the MBBA. I'm Adeola Adejobi.
And I'm Jason Clark, president of the Metropolitan Black Bar Association. The MBBA is the largest association of predominantly African-American attorneys. Our goal with Raising the Bar with the MBBA is to identify justice issues affecting our communities while also trying to identify some solutions in the process.
Today, on Raising the Bar, we are going to talk about criminal justice reform in New York State. Our guests are Karuma James with the Bronx Defenders office and our own MBBA's Asha Smith. Thanks for joining us today.
Thank you, guys.
Thanks for having us.
Great. Well, thanks again for joining us. As we know, there's been a lot of changes when it's come to criminal justice reform. In fact, this has really been a landmark year. There's been a lot of reforms that folks have been trying to get enacted for a very long time, and we've finally been able to do some of those things. So, and we just had our New York State budget was passed on April 1st. So, Asha, can you provide our viewers with a little bit of a synopsis as to what happened?
Well, after a long fight, there was reforms that happened in the legislature, and there's three specific areas that are really important for people that are facing criminal charges in New York and their families and just citizens in general. And there's bail reform, there's also discovery reform, and there's also speedy trial reform. And I think for me, the most exciting thing is bail reform, and that's because it means that people that are charged with nonviolent offenses, mostly misdemeanors, they won't face a cash bail situation. So all of this starts in January. It's going to start taking effect in January of next year. But in the past, and even to today, someone charged with something, say, shoplifting, which is called petty larceny, they could be facing a bail of a large amount of money that they don't have the means to pay. What this new legislation does is that prevents that from happening, meaning that if they're charged with a nonviolent offense, which shoplifting is, they're not going to be staying in jail. That's not the case now. Why it's so important also is that because now, well, in January, the judges will have to take into consideration someone's financial ability to even afford to pay any bail if they're charged with, say, a higher offense than a misdemeanor. They can't just set like $1 million bail on someone that's not working, which is, there's nothing preventing them from doing that now. So it just kind of levels the playing field.
What's also really important about this dynamic is that the lion's share of people who were in jail, like Rikers, for instance, were there for charges that were either nonviolent or because they just couldn't afford to pay bail to get out. So these are people who were in jail not because they pled guilty, not because they were there because they're being punished, but just simply because they couldn't afford the bail. And this is going to have a massive impact on so many thousands and ultimately millions of New Yorkers for really a generation to come. I'll say that one of the great things about this is that I've had so many clients who are charged with everything from marijuana possession to drive with a suspended license, or as Asha mentioned, for petty larceny, for shoplifting, who have to make a decision. Well, since I'm facing jail time, the prosecutor knows that I can't get out, knows that I can't afford to pay the bail, and is probably only going to offer me jail time to plead guilty to. So many times people who would otherwise want to fight their case, if they were outside, are stuck having to make really terrible decisions. Do I want to take jail time now and sit in jail for a few more days or for a few more months? Or do I want to risk the chance that maybe I can fight my case 6 months, 8 months down the line and wait in jail the entire time? This is going to have a huge impact throughout the entire system and really change people's lives.
I think that everyone knows the story of Kalief Browder, and he won't be forgotten because part of the reason why this legislation was passed is because of what happened to him.
Right. And just very quickly, who is Kalief Browder, in case people didn't know? In the very, very short version.
Yeah.
He was a young man that was incarcerated on charges that were pending for years because he couldn't, and his family couldn't afford bail.
And it's for allegedly stealing a backpack.
Yeah, allegedly stealing a backpack. And due to the things that happened to him when he was incarcerated, he ended up
Committing suicide, unfortunately, at the end.
Right.
Now, he was in jail for nearly 4 years just waiting for his day in court. not because he'd already pled guilty or because he'd been found guilty of anything, waiting for his day in court, and then ultimately all the charges were dismissed. And one of the things that would have completely changed maybe even his own life was not having to sit in jail for 4 years, to be subject to violence from other people inside, violence from corrections officers, being subjected to solitary confinement. All these kinds of things happen. And ultimately, all the problems that we see with a place like Rikers, for instance, or other jail facilities, it creates kind of a powder keg when you have so many people who are there and who know that they have been found guilty of anything and want to be able to get out. It just creates a toxic environment, and these are the kinds of things that are really going to make a huge difference. One thing I also want to point out about the bail reform is that now it's not just the judges have a decision to make, it's also police officers. The law also includes a provision that says if police officers run across someone who doesn't have a criminal record or they're charged with something that's nonviolent, they can issue what's called a desk appearance ticket, meaning they're not going to process that person, take them to the precinct, book them into court, they have to see a judge. They're going to give a ticket, allow a chance to come back to court. We see these kinds of cases all the time. Hundreds of people will come back to court on their own. You give them a ticket, you give them a warning, people will generally come back to court. And that's one of the issues that we saw generally is that a lot of times bail is just there to make sure people come back to court. Right. And I got to say,
or so they said.
Or so they said. I don't need to be in jail to show up to some place, and most people don't either.
Yeah.
Right. Yeah, and one of the stats that I know that we're going around after this is the fact that it's estimated that about 90% of the folks who are currently in jails like Rikers will no longer have to sit in jail before they actually have to have their day in court, which is just amazing that there could be these huge type of changes. We started talking about cash bail. We're generally talking about that issue. Can we flesh out a little bit more about what cash bail is, and now if cash bail is no longer generally going to be used for nonviolent low-level offenses, when is bail going to be set for folks on what circumstances?
For serious felonies. I mean, if someone's accused of murder or armed robbery, that's a serious felony. It's not the same level of offense as a shoplifting.
Or a turnstile jump for that matter.
Right. Also, domestic violence cases or criminal contempt where orders of protection are in place. The judges can consider bail in those situations. However, they still must consider a bail that's within the financial means of the person that's being accused of the crime. There's also alternatives to cash bail. There's credit card bail. There's something called a secured bond. There's also electronic monitoring where a person is going to be able to wear an electronic ankle bracelet. There's also reporting into sort of like a supervision. So there's alternatives to ensure that people come back to court, and it's not just cash bail, which, like Karumi was saying, adversely affects people that don't have money because they can't make the bail and their families can't make the bail. That has huge implications too for people that are charged with offenses that could still continue to work to support their families and to help their families. When they're incarcerated, they can't do that. So, I mean, I hope I've answered, those questions. We could go on about this for hours and hours and hours. I mean, I'm sure we'd be happy to. But that's some of the things that the new legislation is going to change in New York City and the state, actually. And I'm excited about it. I think people will tell you that it's huge. Yeah. And it brings New York State back to the forefront of law, because New York State is known as one of the leaders of legal theory, and we were behind. Yeah. We're so behind, and now with this new legislation, we should be leading the way.
Right, and to also add to that, and you already touched upon it a little bit, but can you all talk a little bit more about how this is really going to positively affect families?
Well, I'll tell you that we both, I'm sure, have had so many people who we have to visit at Rikers or at other jail facilities. When somebody first is arrested, a lot of times that's one of the most traumatic experiences that they may have ever had to experience. And there's so many times that I've talked to family members. Even yesterday, I was talking to a family member of a client who was trying to understand, well, why is my significant other still in jail? If I know that these charges should be dropped, I know that they're false, and that, when is he going to be able to have a chance to fight his case? It's like, well, there's really no opportunity for us to do anything other than if you pay thousands upon thousands of dollars of your own hard-earned money to make sure that he's released. And there's no other opportunity after that first time that they see the judge in order to change that. It's hard to describe how many people that this is going to change lives for, because whenever someone's arrested, that's not just affecting their life, it's affecting their spouse's life, their children's lives, their family's lives, their friends' lives. I've seen so many times where somebody comes to court, they don't come to court by themselves. It's their mother, sister, cousin, brother, niece, nephew, and everybody's there to support this person. And what the challenge is that, sometimes we'll ask people, well, do you have the bail? Well, I don't have the bank account, or I don't have the pay stubs, or I don't make enough, or things like that in order to pay the bail. And the other challenge too is that people often have to work through a bail bonds agency, where that agency is taking additional fees as well. So the costs on people are really enormous. And I work as a public defender, where the people that I work with are people who cannot afford to hire their own lawyer or investigators, or also pay bail for that matter. And it's going to make such a huge difference for clients that I've seen time and time again who have to make the decision of, well, should I just plead guilty to a misdemeanor or worse, or jail time, just so that I can get released? Or can I have a chance to have my day in court and really be presumed innocent throughout the entire time that my case is going on?
So speaking of day in court, another key provision in new legislation is speedy trial reform. And so I'm going back to Kalief Broder because there's so many things about his case that influence this legislation passing. I know we talked about bail already, but there's also the thing called speedy trial. And what that means in a nutshell is that when someone is facing charges, the prosecutors have a certain amount of time to proceed with that case. So misdemeanors have a certain amount of time, felonies have a certain amount of time. And they're supposed to be ready for trial in that period of time. Otherwise, the person should be let out of jail, the case should be dismissed because they can't proceed. Right. So we know that didn't happen in Kalief Broder's case. Right. He was just incarcerated so long, for years, and the prosecutors were never ready.
Yeah, and actually, as you're talking about that in speedy trial, what was the reason why he was continually being in jail? Because I imagine that's a case that I think is very similar, obviously in an extreme version, but very similar to some other folks.
One of the problems with the way that the law was written was that there's a number of exceptions for that clock that's supposed to be running. For misdemeanors, that clock is 3 months for start until the case is going to trial. For felonies, it's 6 months. Start, case goes to trial. How does a case last for 2, 3, 4 years, right? One of those reasons is because there's so many different exceptions to when, if the prosecutor, for instance, they're kind of the drivers of the case, if you think about it. They will say, yes, I'm ready to go today, and then come to find out 2 weeks later, well, you know what, I really wasn't ready to go because the police officer's on a special assignment, because I'm out sick, because I can't find my witnesses. Now, if the prosecutor only requests for a week, but they're really not ready for 2 months, then the rest of that time doesn't count. If the court, for instance, has too many cases on, that time doesn't count. If
motion practice is when each side does submits papers to the court for consideration, that time doesn't count. Mm-hmm. I mean, the reasons that were given for why Kalief Broder's case, takes so long, we'll never know actually what happened. All we know is that it didn't happen in 6 months. Mm-hmm. So he spent years incarcerated, and the reasons that people gave, I'm sure, were numerous. It's possible that, and I don't think that this happened, but it's possible that maybe they were ready for trial one time, and there weren't any available courtrooms to do a trial. That also happens too, due to the number of cases in the system. But at the end of the day, why should someone still stay in jail if no one's ready? That doesn't make sense. So what this legislation does is it just, I guess, puts the prosecution's feet to the fire, and that you have to be ready for trial. And if you're not ready for trial, then this person does not need to stay incarcerated. And it's a lot of technicalities, but say someone is charged with a number of offenses, 7 offenses, and perhaps they're ready on 3 of the offenses. Well, if they are not ready on the other 4, then those 4 should be dismissed, and they can proceed on those charges that they say that they're ready on. But they shouldn't just be holding everything up and holding actually justice up until, whenever, they decide that they're ready.
One thing I'll say is that one of the great things about this law is it gives judges more power to push prosecutors to be ready and to explain whether or not they really are. So if a prosecutor gets up and says, yes, I'm ready to go for trial today, the judge has the power to now really, and is encouraged to ask, are you really ready to go? Do you have your witnesses? Do you have all the materials? Have you turned over all the discovery, which I know is another big thing that we're going to get to the defense? These are things that are going to make a huge difference because many times if a prosecutor says, well, I'm ready to go, and then all of a sudden we come to find out, which has happened plenty of times, that their witnesses aren't available, that the police officer is out on vacation and they haven't talked to this person in months or even a year. There's very few times we get a chance to go back and argue, well, they weren't ready at that time. How come nobody asked them these questions? And then we need to get this case dismissed. So we're hoping that this is really going to help move cases forward, that case don't drag out for so long. And let's think about what the impact is. When you have an open case and you're charged with a crime, and that means you have to show up in court every single time. That means you have to take off work or arrange childcare for your children or miss pay, or you might even lose your job. I've had so many people who have lost their jobs, not because they were found guilty, just because they had to keep coming back to court because they didn't have enough sick days or they didn't have enough time off or their boss was frustrated with having to rearrange the schedule all the time. So this is going to save, hopefully, thousands of people's hours of time, of wasted time, coming, sitting in court, just to have their case pushed on again and again and again.
When a prosecutor said that they're ready, say they say that they're ready on Monday in 2 weeks and they ask for 2 weeks and miraculously they get 2 weeks because court calendars are really, really busy. And then when you come back on 2 weeks, they're not ready. Well, now the judge has to say, what happened in those 2 weeks? Why were you ready 2 weeks ago and why are you not ready today? And that's an inquiry that I don't think didn't happen and still doesn't happen. You know, the judges will have to get used to this. It does also put the fire under the judges to take a more active role in making sure that these cases go forward. And again, holding the prosecution's feet to the fire. It's like, this is what you're supposed to do, and you will do this. And records shall be made. That's another key point, that the record has to be clear. Like, all this has to be done on the record, which means that it's being recorded, transcribed by the court reporter. But a record needs to be made so you can see everything that's happening. Nothing that's going to happen in a cloud of smoke now. It's supposed to be clear and so that everyone knows what's going on.
Two quick things, because there's so much here.
Yeah.
I'm already seeing this, even as you're going. But very quick, one is if you can just speak a little bit, because I imagine from some of the prosecutors, what they'll say is it's not that they are just being lazy or that they don't want to do it, but it may be.
We didn't say that.
No, right.
I don't think I remember saying that.
What the issue would still be, I imagine some of them would say if they were here, is that if there's a lack of resources, how are they supposed to get it done within a certain amount of time? So I want to hear your comment in regards to that. And then the second is just going back a little bit, when we were talking about bail reform, because I think this is an important point we also want to make, is when bail is being set, one of the issues that came up had to do with the idea of dangerousness and whether a judge can determine whether use that as a component when determining their. So you can answer those two things. Yes.
That's it.
That's a short answer.
No.
All right.
No, answer is
Great.
no. They shouldn't be using it now, and they cannot use it again, in the future. No. As for lack of resources, what does that mean?
Well, I guess I'll just jump in terms of the bail issue. New York State was one of the states that said, we don't consider safety to the community, dangerousness of the offense, things like that, as a part of the bail anyway. That was already part of the law before these changes. And both the legislature on either side said, we don't want this to be an element in how we think about bail. Because if you think about it, this goes to the heart of what's a core part of the criminal justice system. People are presumed innocent from day one all the way through the rest of the trial. So we can't allow our feelings, or like a judge's feelings about this charge or this crime or what this means, to impact how they decide whether or not somebody's going to come back to court, which is really the decision that's being made with bail. In terms of from the prosecution's end, look, I'll say that many parties in the criminal justice system don't have the resources that they need to really adequately address all the issues that come up. That's judges, that's prosecutors, that's defense attorneys, that's court officers, you name it, right? But what's important about this is that resources shouldn't trump people's rights. People have a right to have their cases handled quickly, efficiently, and fairly, and in a way that's transparent, and ensuring that if New York State is going to bring charges against a person, they have to make sure that they have valid reasons for doing so, that they actually prosecute the cases fairly and expeditiously, and that people know what's actually happening in their cases. That's only fair.
Right. Right. And I want to take you back really quickly to the judges, right? Because we're saying that now judges have more discretion. But can, for the audience, can you talk a little bit more about what the judge's discretion was before, so they can really kind of see what the real impact is with this legislation?
I mean, do you think they didn't have discretion or they didn't exercise it?
I think that varied. I think.
Yeah, it's a very thin line because judges have always had discretion. It's just a matter of, I think, how they viewed the law and what they did and what other judges did before them. But this is like a new ground, but the legislature is very specific about what they want the judges to do. Like when they put language in there saying what the judges should do, like that is something I don't think that we've seen before. It's like sending them a message, this is what you need to do. And so they have to follow that.
And I think, just to be fair, I mean, a lot of judges are going to be cautious because they have a very important role to play. They're deciding people's fate, their lives, and have a huge impact on what happens in individual people's cases. So any judge is going to want to be careful about how they make decisions about somebody's bail, about whether or not this person is going to stay free, be free, or go to jail. And what's different, to Asha's point, is that judges have additional things that they can consider and different ways that they can actually help move the process forward. So instead of it just being reliant on this particular judge, that particular prosecutor, that particular case, now all judges have additional tools so that they can make sure the process moves forward in a better way.
And what are some of the factors that a judge then can be able to use? So let's say there's a case before the judge trying to determine whether bail should be set. We're talking about, let's say, a violent felony. Like, what are some of the factors that are permitted under this new legislation?
So one of the factors, and this has been there before, but one of the additional factors is ensuring this person's ability to actually pay. That's one of the biggest changes. That just wasn't one of the factors really before in the bail law, is we have to consider, can this person pay bail? Can their family pay bail? And that will impact the actual decision. One of the things that was certainly there before but wasn't as exercised as much is there's all these different alternative ways to make sure a person comes back to court. Electronic monitoring is really a new thing. That's not something that was really a part of the bail law before. There's other forms of, there's a program called supervised release that's, at least in New York City, is basically a person signs a contract with an agency in the court saying, yes, I'm going to come back to court. No, I'm not going to get rearrested. You sign it in front of the judge, in front of the court, on the record, in front of your lawyer, in front of the prosecutor. That's a program that has been a pilot program in New York, has been really successful. That's something that the law now says these kinds of programs are things that judges can consider. Judges can also consider the person's, and which they did before, the person's criminal history, so their community ties, things like that. So there were actually a lot of really great considerations that judges can make in the law. The law is now actually expanded to ensure that they can consider even more things to really think about this person who stands before them as a real person and whether or not we can be sure they're going to come back to court.
I mean, I would say we have to generally probably come back in a year after, things start in January when the law takes effect and we start seeing actually what's going on. Right. Because right now we can tell you what the law says and what's supposed to happen, but we don't actually know how it's going to be implemented. I think that is going to be interesting and another conversation to talk about what we actually see.
I will say the one thing I'm really looking forward to is the discovery reform.
Yes. You have 2 minutes. Yes.
Can't wait.
We probably need to do a different show on that because it's so huge.
So what is the reform, just very quickly, before we have to finish?
Just so everyone understands, discovery means evidence that the prosecutor has and that defense attorneys have. They're supposed to turn over. It's all about information sharing, right? So if a prosecutor has photos, video surveillance, statements from witnesses, things like that, or proof that this person didn't commit this crime. There was a lot of rules that allow prosecutors to hold on to that evidence right before the trial, or sometimes at the
day
very
of trial.
The day of trial.
Counsel the evidence.
And I imagine when it comes to plea bargains and things like that, that can play a very influential role.
It makes a huge decision. I've seen situations where good or bad, right? If someone says, you know what, this didn't happen, I don't remember this happening, things like that, and then all of a sudden we have a video showing like, no, actually, this is exactly what happened. It allows people to make better decisions. Or on the other side, this actually happened. I started a trial a week ago where my client's case had been dragging on for a year and a half. They're actually in jail that entire time because the bail was so high and they weren't able to get released. We didn't get witness statements from the prosecution that one of the eyewitnesses lied to the grand jury at the very beginning of the case. We didn't find that out until a year and a half later, how weak the prosecution's case was. And it wasn't until then that we knew that our client shouldn't have been in jail for that amount of time, that the prosecution's offer should have been a lot better. That would have changed the entire way that we even approached the case from the very beginning. There's witnesses that we didn't know existed until the very end that we could have interviewed and talked to at the time to make sure that they're actually telling the truth. These kinds of things make a huge decision. It just, imagine if...
Why would they hold back that information? That's the issue. Why?
Exactly.
Why hold it back?
Right.
And it just really wasn't fair. It's just like, imagine if you you wanted to buy a new cell phone and you'd had to walk in there blind. I don't know what the brands are. I don't know what the features are. I don't know what the cell phone plans are. Nope, here's you have one basic phone. I'm not gonna tell you about all the other phones that are here, all the better plans, things like that. And you might not find out for a year and a half later. Imagine how you would feel just on something as simple as that. And now we're talking about people's freedom, where they didn't have access to the information that they needed. This is going to make a huge difference in the entire system.
Yeah, we'll have to take you up, come back in a year and see exactly where things are.
Exactly.
Yeah. Actually, one thing I want to highlight is that there have been some DA offices. I know like the Brooklyn DA offices have been trying to do some of these things with discovery reform, but now it's codified. So if we're talking about some of the other counties, let's say in upstate New York or what have you, maybe now they have to do these type of things. So it's going to be interesting to see how these things happen.
We'd love to come back in a year.
Exactly.
Right.
Your rights to information shouldn't change just based on the zip code that you get arrested in.
So historically, bail has been used to kind of penalize people, and it's been used in a more of a punitive way, right? Yes. And so now with these reforms, it seems like a lot of that has been, taken away. Can you talk a little bit more about that?
You're so right about that. It did, especially standing next to someone accused of a crime when bail is being set, it did seem punitive based on whatever the prosecution presented as a story about what was going on, and if a judge would look at someone's previous criminal history. Now that's gone. Well, as of January, that will be gone, and there'll be other factors to be looked at. Right. And it will be more fair. I think the fairest thing that is happening right now is that someone's ability to pay bail has to be considered, when that just isn't the case now. And, to be perfectly honest with you, most of my clients throughout the years were people that looked just like you and me. That's the majority of people I saw coming through arraignments. That's the majority of people that I represented. That didn't have money, that didn't have anybody to speak for them. And yes, they were punished, not just by bail, but by the criminal justice system per se. Right. So this does level the playing field. It's so important.
There's so many people that I represented many times who are struggling with drug addiction, with homelessness, or who were just low income and just didn't have the kind of resources that they needed to fight their own cases. And this was really a huge penalty on poor people at the end of the day, is that just because if you were low income and you needed treatment instead of handcuffs, you were brought before a judge, and that's what a judge is looking at, is that, well, I know this person doesn't have the money. I know that this person may have had previous cases because they're battling with an addiction. A lot of judges would take that into account, others may not. And so what's really huge about this is that means that just because you're poor, just because you don't have money, doesn't mean that you can't fight your case and that you can't have your freedom.
Yeah, right? And you said something earlier before we closed it I thought was very powerful, where you said resources should not trump rights, right? The fact that you don't have access to money or because of your community or your background, your rights should not be taken away. And so I think that's really, really powerful. And so I'm glad that we were able to talk about this today, and I'm glad that there's some changes happening in New York City. And so that's all the time that we have today, but I want to thank our guests for being here with us today.
Thank you, guys.
Great, thank you.
My name is Jason Clark. This is Adeola Adejobi. Thank you for watching Raising the Bar on the Manhattan Neighborhood Network. See you next time.